Good morning, everybody. We'll go ahead and get started. Welcome to the Nelson Mullins webinar, HIPAA High-Tech Update, 5 Takeaways for 2015. I am Eli Polikoff in the Charleston, South Carolina office of Nelson Mullins. The Healthcare Technologies Group at Nelson Mullins is pleased to offer this webinar today to our clients and other interested parties. Nelson Mullins includes a number of attorneys who practice in a variety of aspects of healthcare, technology, data security, and corporate law, which now overlap in many ways. Our webinar today provides an update on the HIPAA high-tech regulations with an emphasis on upcoming trends and challenges for 2015. With me are Gary Capps in our Columbia office and David Capps in our Atlanta office. Our practices include a considerable focus on HIPAA compliance and related data privacy and confidentiality issues. As you know, in 2013, the federal government significantly modified the HIPAA privacy and security rules as required by the HITECH Act of 2009. This webinar is not intended to review all of the 2013 regulations. Rather, this webinar looks ahead at upcoming trends and high-tech challenges. What is next, and what can we learn from the record-setting HIPAA penalties that were assessed in 2014? Just a couple of housekeeping items. If you're not able to see the slides, just follow the directions from the webinar program. We will also make them available after the presentation on this website. We'll post a recording of the webinar as well as copies of the slides. We'll send out an email this afternoon. They'll have this link here. This website also includes our webinar from 2 years ago that provided an update and a review of the final rule that was issued in 2013. This webinar, as I mentioned, specifically detailed the changes presented in the final rule. We encourage you to take a look. Should you have any questions during the webinar, please submit them through the questions function through the webinar program, or feel free to email one of us, and we'll try to talk through some of those questions at the end of the webinar today. So kind of the points we're going to talk about today, 5 general topics. Many of you submitted questions in advance of the webinar, so we tried to tailor it to some of the common themes that were asked. The first point is a quick refresher on the high-tech requirements, the deadlines and the requirements. We'll talk about pending high-tech regulations, some of the unresolved provisions. All of the high-tech rules are not complete. We're still waiting on the federal government to issue some regulations. HIPAA audit programs, lessons from the 2014 penalties. We'll go through some of those. And then vendor management and liability issues. We'll talk about those as well. Just a quick HIPAA high-tech refresher. As you know, the HITECH Act was passed as part of the 2009 Stimulus Act, and it required and mandated a variety of changes to the HIPAA privacy and security rule. These changes were finalized in the January 2013 final rule, also known as the Omnibus Rule, that changed a variety of the HIPAA regulations. This was a 500 pages or so, very interesting reading, and if you're so inclined to read it, you can go to the website and take a look at it. As a general matter, all of these requirements had a compliance deadline of September 2014 at the latest. Okay, a brief review of what HITECH did. This chart visually represents the major changes presented by HITECH. The parts in red are the new parts, and there are 4 concepts here that we just want to quickly review. The first is that many of these obligations, HIPAA obligations, now extend directly to business associates, most importantly the security rule. Previously, they did not directly apply. Second, business associates are now directly liable to the federal government for HIPAA compliance. Previously, the liability was through contract law. Now the government can directly touch the business associates. Third, HIPAA clarified and expanded the definition of business associate, Entities that access, create, receive, maintain, transmit patient information really need to take a close look as to whether they fall into this category. And this definition includes the subcontractors that provide services to the business associate. And fourth, HITECH required business associate agreement subcontracts between the business associate and the subcontractor. And again, on the website that we have summaries from when the rule was issued that go into much greater detail on all of these points. Other HITECH changes, just to briefly go over, this list lists the major ones. The breach notification rule, changes to business associate agreements, notice of privacy practices, changes to how PHI can be used for marketing and sale and related issues. So on the horizon, kind of what's next, especially in 2015. The pending rulemakings, there are 3 significant changes mandated by the HITECH Act that are not yet been implemented. The statute from 2009 requires these changes, but the regulations have not yet been issued. They were not included in the 2013 omnibus rule. The first one being the accounting rule. HIPAA permits individuals to request an accounting or a summary of certain types of disclosures of their health information. HITECH requires an expansion of this right in a variety of ways. In 2011, the government issued proposed rules to implement this change. It was met with considerable resistance. It expanded it in a number of ways, and it would be rather challenging to comply. The omnibus rule did not adopt this proposal, and it remains under consideration almost 4 years after it was initially proposed, and there is some thought that this will come out this year. The second category, the minimum necessary guidelines, HITECH required the federal government to issue guidance on the minimum necessary standard. Minimum necessary is the idea that only the minimum necessary PHI should be used, accessed, or disclosed to satisfy a particular purpose. The final rule did not include this guidance, and it's still pending. Also of note is the so-called HIPAA whistleblower or bounty hunter provision. This is where HITECH required the federal government to develop a methodology to permit individuals harmed by a HIPAA violation to receive a percentage of the penalty assessed against the covered entity or business associate, so thus called the whistleblower provision of HITECH. The final rule did not address it and noted it would be subject to a future rulemaking. Obviously, this is of considerable interest since it incentivizes individuals to identify and pursue a HIPAA violation. Other things to be on watch for: the audit programs. The HIPAA compliance audit program, HITECH mandated that OCR perform random HIPAA compliance audits. These are administered by a private contractor, and these are in addition to audits that result from a reported breach. Phase 2 of the audit program was announced last year. It's going to roll out this year. Areas of focus include the security rule risk assessment, breach responses, and a variety of other issues. Related to this are meaningful use audits for covered entities. In 2010, since 2010, the federal government has allocated over $20 billion with a B in incentive funds to healthcare providers to encourage the adoption of electronic medical records. One of the requirements in order to receive these funds is to meet certain HIPAA requirements, including a security rule assessment. And the federal government has started to audit recipients on whether they meet these requirements, including the HIPAA portion. Failure to comply with these requirements, including the HIPAA segment of this, can lead to recoupment of incentive funds, and investigation, or worse. So these two programs, these two audit programs are related in the sense that they can both look at HIPAA-related issues. Other things on the horizon, the HIPAA private cause of action. HIPAA does not permit individuals to directly sue covered entities or business associates for HIPAA violations. Rather, their remedy is through enforcement by the federal government. Now, nonetheless, individuals continue to try to bring lawsuits against covered entities and business associates for HIPAA violations, often using HIPAA as the standard of care regarding disclosure of health information. These are essentially HIPAA lawsuits wrapped in state law negligence claims. Some of these have survived court rulings, and it's led to a variety of court opinions, typically in state court, over how individuals can use HIPAA against healthcare providers and others. There are cases all over the place. It's rather inconsistent, and it's certainly an important issue to stay abreast of due to the increased public attention to data security issues in healthcare and in other contexts. Finally, the idea of disclosures for treatment purposes within so-called narrow networks and ACOs, related entities. This is the idea of disclosure for treatment purposes within these entities or affiliated entities that are trying to coordinate care. HIPAA does permit the disclosure of PHI for treatment without patient authorization, and no BAA is usually needed. Nonetheless, covered entities are wise to think about how such information can be used and disclosed and accessed, especially when it involves a direct link or access into an electronic health record system. So I'm now going to turn it over to Gary Capps, who's going to talk about some enforcement initiatives and assessments over the last year. Gary?
Thanks, Eli. I'm going to spend a few minutes just discussing some of the HIPAA enforcement actions in 2014. 2014 was really an interesting year for HIPAA enforcement. As Eli mentioned early on, there were some record-setting penalties in 2014, and we also got some valuable insight about where OCR may be heading in 2015 and beyond in terms of penalty enforcement. The first slide here is just an overview that discusses the penalties that are available to OCR. You can see that the penalties range from as little as $100 per violation up to $50,000 per violation, and it's essentially based on the violator's state of mind at the time of the violation. The maximum amount of penalties, as you can see in the far right column, in a calendar year for an identical violation of an identical provision is $1.5 million. Just by way of background and overview, as I'm sure everyone on the call knows, HIPAA enforcement is administered by the Department of Health and Human Services Office for Civil Rights. So I'm going to discuss 4 resolution agreements that I think highlight some of the points, of the high points from 2014 in HIPAA enforcement actions. The first was the record-setting penalty that we saw here. It was the largest settlement amount to date for a HIPAA violation, $4.8 million. This violation involved 2 affiliated New York City hospitals that are large, well-known hospitals throughout the country. This all began with an employed physician who was allowed to have his personal server that was on the hospital's network, and it had PHI on the server. As a result of an attempted deactivation of that server, PHI was accessible through internet search engines like Google. OCR found that there was a failure to conduct an accurate and thorough risk assessment and to implement appropriate policies and procedures for authorizing access to databases. The lesson here, I think, is whether you're a small entity or large entity, and even if you are a really large entity like these New York hospitals who had plenty of resources and access to personnel, you can still get in trouble by not having adequate risk assessments conducted, adequate policies and procedures in place. It can still present a stumbling block no matter how large and sophisticated of an entity you are. So now going from really big to really small in terms of a really big hospital system in New York to a really small rural county in Washington State, this resolution agreement involved a small county, 118,000 population, that filed a breach notification with OCR that said there were 7 individuals whose PHI had been inadvertently disclosed and made publicly available through disclosure to a server that was maintained by the county. Later, after the OCR launched their investigation, the OCR actually learned that rather than 7 individuals, it was 1,581 individuals whose information was publicly accessible. OCR found that the county had failed to provide notification to these additional individuals, of course, because the county wasn't even aware until OCR began its investigation that these individuals' information had been made public. OCR also found that the county had failed to implement sufficient policies and procedures to prevent and detect and correct security violations. Finally, OCR found that the county had failed to implement and maintain security rule compliance policies. The lesson here, I think, is that if your house isn't in order, what begins as an isolated breach can lead to the discovery of other HIPAA compliance issues. Here, the county reported what they thought was a small violation, 7 individuals, that turned into in excess of 1,500 individuals once the OCR began investigating. Another point that I think is worth making here is that this is the first time that OCR has entered into a settlement agreement with a county government. OCR is really sending a strong message here about the importance of HIPAA compliance regardless of the size of the entity. The next resolution agreement that I'm going to discuss involves what on the surface appears to be a very mundane violation. An unencrypted laptop is stolen. We've heard about this a million times. What's interesting about this particular settlement agreement is that once OCR began their compliance review, it revealed that the provider had previously recognized in multiple risk analyses that a lack of encryption on its laptops, desktops, medical equipment, tablets, and other devices was a critical risk, and those were the words used by OCR, critical risk. The provider's response, according to OCR, was incomplete and inconsistent. So we saw a $1.7 million fine here, and the lesson to be taken from all this is this provider had gone through all the trouble of conducting a risk analysis, and the risk analysis, actually multiple risk analyses, and had discovered that these were critical risks, yet they hadn't taken the steps to actually carry out the resolution. And so once a risk is identified, appropriate steps really have to be taken to address that risk. My final slide here just reminds us that paper is still important. I think we all tend to think these days in terms of how important electronic protected health information is and the technical aspects of data. But we see here that really paper is important, and we have to be thinking about how to protect and secure paper when it's in transition. This particular settlement agreement involved a physician who was considering retirement and having her practice be purchased by a hospital. She transferred 71 boxes of medical records, some 5,000 to 8,000 medical records, to the custody of the hospital. The hospital took custody of those. Ultimately, it was determined that the deal wasn't going to go through, and so the hospital decided to return the medical records to the physician. Unfortunately, the hospital knowingly returned those medical records to the physician's home when the hospital, according to OCR, knew the physician was not going to be home, left those 71 cardboard boxes on the physician's driveway, which was about 20 feet from a public road and near a shopping center. We ended up with an $800,000 fine here, and I think the lesson here is that training is still critical. There were undoubtedly several people involved in the decision-making chain that led to these boxes being left on the driveway. It wasn't just one person someone somewhere along the way should have stopped and said, we can't do this. We can't leave these medical records out in the open like this and walk away. So with that, I'll conclude my portion of the presentation and turn it over to David.
All right, thank you, Gary. We're going to switch gears a little bit, now talk about vendor management and liability issues. As background, under HITECH, a covered entity can be liable for the acts of a business associate in certain instances as noted in the HITECH regs. Same concept applies to a business associate's liability for acts of a subcontractor. However, even outside of the direct liability issues, a covered entity can face numerous indirect costs in the event of a breach, ranging from the costs associated with the breach, the notice, related actions, public sentiment, third-party claims, brand damage, etc. So it's an important issue. I'm going to turn it over to David Katz in our Atlanta office to talk about some vendor management issues and considerations. David regularly deals with data management and privacy issues in a wide variety of settings, including the non-healthcare context. So, David, take it away.
Eli, thank you very much. It's so great to be with you all today. So we've included with the next 3 slides a list of questions that we think would serve to establish a checklist for you to use as you're talking to vendors. But I want to go through and give you a little bit of background and set the table a little bit for what the objectives are with this process. And really what you're trying to do for the organization is you're trying to get in a position to ensure that the downstream data supply chain is sound. And let me say that phrase to you again, the downstream data supply chain. It's really the responsibility for the organization negotiating with the vendor to understand how the vendor is using and securing that data. So the 4 objectives that we want to discuss in terms of being able to conduct your diligence is the first category is you want to understand the privacy and data security risks that exist. And how you do that is by asking a series of questions to those vendors and really treating this at the outset of negotiations for the contract as a period to conduct some due diligence, to be able to understand your risk, ultimately for the purposes of being able to transfer as much of that risk through the contract, and not just through the business associate agreement or the sub-BAA, but through the actual contract with the vendor. And finally, using that due diligence period to obtain as much assurance as possible about how data is being maintained. So at the outset, in conducting that risk assessment, one of the things you want to be asking your vendors for, to the extent they're willing to provide it, is whether they conduct periodic risk assessments and whether they're willing to provide copies of those risk assessments, vulnerability assessments, penetration tests that they've conducted over the last 5 years. Do they do that on a regular basis? And will they be willing to provide those assessments to you? And will they provide a detailed summary of the risk assessment and risk management programs that exist, and along with copies of those programs? So that's the first step in getting you to in a position to understand what the risk profile is of the vendor. The second area, the second objective, is being able to understand the governance infrastructure that that vendor maintains around privacy and security controls. And so in part of being able to determine the answers to those questions is to be able to ask for documented information security policies. Are they maintained? Who controls and owns those policies? Who's responsible for updating those policies? Are there information classification guidelines to categorize the types of data that are coming from you to the vendor? Do they have information governance guidelines and standards? And are they separating data into categories that require more strict protection and controls? And are they willing to give you and provide you a copy of those policies so you can, from your perspective, understand what controls they have in place and how effective those controls might be? Then you want to be able to properly evaluate their ability to apply those administrative, physical, and technical safeguards as required under the security rule. And so this means an understanding of how they've identified individuals within their organization that have primary responsibility for privacy and data security. Are they willing to provide the monitoring procedures for their information systems that are maintaining the data? Are they willing to provide the physical security guidelines to ensure that the physical locations where that data is being maintained are secured? And are they willing to provide guidelines around hiring personnel that involve background checks, credit checks, and other screening procedures to understand who actually is going to be touching data on their premises and in their business. And finally, you want to be able to ensure that there's an adequate process for notification in place. And some of the best guidance with respect to vendor management and incident notification can be found in ISO 27002, which is the Code of Practice for Information Security Management. And ISO is the international standard for organization. It's published by a private consortium that publishes these guidelines. And there's a section under that guidance that involves information security management and provides guidance on the kinds of things you should be looking for within an organization for controls around how information security incidents are being reported and monitored. And so if the vendor is not utilizing a program on site with their employees regarding their responsibility to report information security incidents, that should be a red flag. And those reporting procedures should really include a feedback process to ensure that individuals reporting information security events are notifying others of the results after the issues have been discovered, that there are forms that exist to report actions, and there are persons reporting all the actions that are taken in response to the events, that behaviors are being modified if events are being underreported. And through that guidance, you can begin to establish some of the questions that will enable you to get good comfort around what controls the vendors have in place for their employees in the reporting of security incidents. And finally, it's really critical that there be planning within your organization to establish an internal team that can begin to develop these checklists to determine the controls that these vendors have in place as you're exchanging data, and finding the resources internally to be able to stand up groups that during the diligence process and the negotiating process can be reviewing the information coming from vendors to provide assurances to the organizations that these controls are adequate and exist. So the slides that we've provided begin to touch on these topics and the broad categories that we've discussed about obtaining these assurances. And we think it's a good place to start in terms of developing your own vendor management program to try and obtain as much information as you can during that negotiating process with those vendors. Thank you, Eli.
Thanks, David. So later this afternoon, we'll follow up with everybody and send a copy of this webinar out, as well as a link that will have a recording to it. If there are any questions, please let us know. We have a couple questions that were submitted, so we'll go over those. Before I get to that, please keep in mind save the date for April 15th, which is the Nelson Mullins Dixon Hughes Health Law Forum in our Atlanta office, followed by cocktails on the terrace in that office. Topics that will be addressed include a view from Capitol Hill on the status of healthcare reform, health IT audit programs, cost report appeals, and related topics. And additional info will be posted at nelsonmullins.com. So we have a couple questions that were submitted both today and in advance of the presentations. We'll try to go over a couple of those. I'm looking over these here. So one issue is penalty avoidance. So the idea of how to stay off the penalty radar. Gary, since you talked about the penalties, you want to talk about that for a second?
Sure, be glad to. I think it comes down to fundamentals, really. It's going through the process of training, conducting risk analyses, and enforcing policies and procedures after you've developed those policies and procedures. Obviously, the first step is trying to avoid a HIPAA breach, but as we saw in several of the resolution agreements that I discussed, the real problems begin after the HIPAA breach has occurred, and OCR begins the investigation and learns that the house really isn't in order, that there are a lot of HIPAA violations that they can focus on from that point forward. And so I think whether it's in terms of having all those processes in place to avoid a HIPAA breach, or once a HIPAA breach has occurred, to try to mitigate the issues that arise from that HIPAA breach, those are the steps that you should really take.
Okay. A number of questions about vendor management, business associates related issues. One important step to think about here is doing an audit or an inventory of potential business associates. So identifying all vendors, identifying which ones have access to PHI, and then which ones meet the business associate definition, and then putting in place the proper agreements. That is a core step that needs to be taken. Outside of that, there are a couple questions on what type of due diligence questions should be asked by a covered entity or business associate when they're evaluating a third-party vendor. David, if you want to expand on that a little bit, since it's related to what you covered here today.
Sure. So I think it's really important that the covered entities and business associates and everyone in that data supply chain really understand what kind of controls are in place within those organizations for reporting security weaknesses or security incidents and improvements. So, a control, for example, would be that the employees, contractors, and third parties in those organizations, are required to note and report observed or suspected security weaknesses in systems or services, that they are required to report those to management or to the service provider as quickly as possible, that those reporting mechanisms are easy and accessible, and that the agreements that you're negotiating with those vendors specifically require the reporting of security incidents. And so, you can tell very quickly in an organization that you're negotiating with or dealing with that has responsibility for data, whether or not they have a mature and robust information security program. And the primary area in which to ask to determine that is whether they have those policies in place and whether they're willing to share them. And if they're not, that should be an immediate red flag about whether the company and the vendor is sound in terms of maintaining the appropriate privacy and security controls.
Great, thanks, David. Some of the questions we got before the presentation really focused on the security rule and security rule considerations as opposed to the privacy rule. So a couple of people asked us to talk about the security rule in general. This is obviously in the news a lot these days. So the security rule itself is a set of administrative, physical, and technical safeguards to protect electronic PHI. That's PHI that is stored or maintained, received, or sent by electronic media. There are two categories in the security rule. Things are required or addressable. The required specifications must be incorporated into the procedures. The addressable specifications must be implemented if it's reasonable and appropriate for the covered entity or the business associate. So that is dependent on the context and the circumstances of that covered entity or business associate. It's real important for that entity to take a look at what types of PHI, how much, and evaluate the addressable standards in light of their specific situation. If the entity, the covered entity, or the business associate determines that an addressable standard specification is not reasonable or appropriate for it, then it must document the basis for that and also adopt a reasonable equivalent alternative. And the covered entity or the business associate needs to modify and update that on a regular basis as circumstances may change. Certainly a lot of concern and focus on the security rule. Another question got kind of before the presentation. If an entity doesn't have a breach, in the absence of a breach, what is the likelihood of coming under OCR's Spotlight? What do they have to worry about? So, Gary, you want to kind of address that?
Sure. On the surface, it would seem that the likelihood of getting the Spotlight from OCR would be really low, because as we saw in all four of the resolution agreements that we discussed, they all began when the entity reported a breach to OCR. But as Eli discussed during his presentation, there was a pilot audit program that began back in 2011, and phase 2 of that program is set to begin sometime very soon in 2015. And so even though you may not be reporting a breach and you may not be in the spotlight with OCR in that way, you could be subject to one of these audits that are coming our way very soon. The OCR announced that there were going to be 1,200 audits in this phase 2, which is going to include both covered entities and business associates. So you can still be subject to audit even if you avoid a breach situation and be in the crosshairs of OCR.
Great. And as Gary mentioned, in thinking about who enforces all of this, who are the HIPAA police? It's the Office for Civil Rights within the federal HHS. Those are the main investigators. However, state attorneys general now have enforcement abilities due to HITECH. This has led to some inconsistent results since you have 50 separate enforcers as opposed to a single federal entity. These AGs, they can bring civil lawsuits. Some have used this power. They do have to notify OCR before bringing an action, but they're allowed to do so. Kind of along the same lines, HITECH streamlined some of the procedural issues related to enforcement, whereas the government previously had a little more discretion. Now they have to proceed more towards a penalty stage review. Looking over a couple questions here. This is, David, I think this is related to a prior question, but when a covered entity or business associate is evaluating a vendor's ability to respond to a breach, if that is a potential concern or issue, what should the covered entity or the business associate be thinking about with regard to their subcontractor?
Sure, just coming off mute. So one of the important things that we're seeing just commercially and certainly in the healthcare context is the negotiation over a cyber liability provision. Because if the entities release data and they have a breach, the issue is certainly going to be what kind of money is in place, for lack of a better word, to really make sure that the damages are covered and the expenses and costs are covered. So negotiating coverage for the entities that are maintaining the data in those agreements and being certain that those provisions are robust enough to cover any kind of loss, any kind of notification, any kind of investigation are pretty important. And we're seeing those amounts in the $5 to $10 million range for breaches. So making sure that those are well covered in the agreement are really important.
Great. We got a couple questions about business associate agreements, the timeline for it, and what's required, what's not. In terms of specific changes to it, the website that we'll send out talks about some of the specific provisions that need to be in there. The deadline for doing it, the compliance deadline was September of last year. People are strongly recommended to update their BAAs as soon as possible. There are a lot of provisions these days that are in these agreements that are not required by HIPAA or HITECH, and a lot of it will fall to the negotiation between the parties and the circumstance of what's going on. As David mentioned, cyber liability issues are prominent among them, as are indemnification and cost-shifting obligations. Well, I think that really finishes it up for us today. We appreciate your participation. As I mentioned, we'll send out a copy of this later on this afternoon or tomorrow morning. If you have any questions, please feel free to shoot us an email. We'll be happy to speak with you. Thank you again.